but I wouldn't be surprised if it's by the end of this week. And this is what I do. I go by what historically she's done. And if you look at previous cases of hers, there's been times where she's done the summary judgment ruling at the same time as the Daubert ruling. There was a case where she gave both rulings simultaneously. And that's why when the Daubert motion came down, I said the summary judgment could be tonight. Then there was another case where she did the Daubert rulings and 2 weeks went by and she gave the decision on summary judgment. And there was a case where she did the Daubert ruling and 60 days between. So although I'm guessing, I can tell you this, that I would be very surprised if it's not within the next 30 days. If late April comes and we're still waiting, I'll genuinely be surprised, and it would be inconsistent with the way she's handled cases in the past. When Ripple's summary judgment decision was published, I came out and said, this is a brief written for the appellate courts, that it was written directly to the Second Circuit and the U.S. Supreme Court. It's already an appeal ready. And if you look, Brad Garlinghouse even said that Ripple was operating as though they had already lost. I don't know if you remember when he said that. And he said, listen, it's not going to get any worse for us than it is now. And basically, if you look at who they hired Michael Kellogg. Okay, Michael Kellogg is the preeminent appellate attorney in the United States of America. Neil Gorsuch, who is on the Supreme Court, used to work for Mike Kellogg, okay, as a partner there. And he used to be a solicitor general. He used to be chief Rehnquist's clerk. And so this brief is written for the appellate courts. And I've come out and said that if Ripple goes to the Supreme Court, they're going to win. Now, that's pretty confident for me to say. I said 100%, I'm sure. And there are not many things you're sure in 100%, because this Supreme Court, it overturned Roe versus Wade. No matter what your position is on it, it was 50-year precedent. They're conservative justices. And if you look at the EPA West Virginia case that Professor J.W. and I talked about recently, that's the case where they slapped down the EPA for extending its jurisdiction without congressional authorization. Does that sound familiar? A federal agency? And if you look at Michael Kellogg and his firm, he's a specialist in regulatory and appellate issues. And so if the SEC were to get an outright win, which I don't think will happen, but if they did, this is going on appeal for sure. Ripple will just continue to do business as they have been, and then we're going to wait and watch for a victory in the appellate court. The best chances for the SEC is right now with Judge Torres at the federal district court for everything I just told you about why Ripple would appeal.
In a nutshell, Ripple wins a case, the SEC threatens to appeal, and then the SEC uses the appeal to secure a settlement with Ripple Labs. The SEC ends up looking like a winner, while Ripple ends up getting the clarity it needs to finally open up its on-demand liquidity solutions in the U.S. corridor, the last piece of the puzzle for Ripple's total global coverage.
If Ripple wins, is Gary Gensler going to be at the SEC several years from now, 5 years from now, if it goes to the Supreme Court? Of course not. So if you know that you're really, really likely going to lose on appeal, but can get a political win right now, what do you think Gary Gensler is going to do? And what I mean by a political win is the best thing the SEC would have if they lose is the threat of appeal. And so do I think they will threat to appeal it? Sure. And what would happen? They would use the threat of an appeal to try to negotiate a settlement post Judge Torres's decision, where they get to say, okay, Ripple will waive our appeal. We'll agree that Judge Torres's decision, that secondary market sales are not securities, and that your ongoing and future sales are not securities, if you agree to pay $25 million, pick a number, right? And Ripple may very well entertain that. And then Gary Gensler could say, yes, we got a victory. We got millions and millions of dollars. But more importantly, he gets to go after his other targets in present day. That's the issue. And so Ellie Tarrant said that they are even beefing up the crypto enforcement at the SEC now, today, even though a year ago they doubled the SEC crypto enforcement. And so why would you appeal it, take the risk of a loss, when you could get that political win?
What a great question posed by John. Why would the SEC be doubling its labor force, specifically in its crypto assets and cyber unit, unless they already know Ripple's going to win?
I'll take it one step further because of that Coinbase interview that Tony did of Thinking Crypto Channel. Think about this. If Ripple wins and Judge Torres says, SEC, you couldn't prove XRP was sold as a security by the actual company that owns 50% of the tokens. Do you think that's going to give Coinbase and Kraken confidence? If you can't prove it against Ripple, then you sure as hell can't prove it's a security when Coinbase or Kraken or Uphold sells it. So despite, I know that the chief legal officer of Coinbase said, well, and he's got to say that it's a publicly traded company. He's going to say we have to be careful. We got to do this. We got to do that. But just think about common sense. If you lose against Ripple, if you can't prove Ripple violated the law, you sure as hell not proving Coinbase or anyone else did. So I think it would be great news for retail as well.
John doesn't stop there. He brought up Hinman's emails too, something that the SEC has been unwilling to provide.
I have to tell you, I've already said it publicly. Eventually those emails are coming out and eventually those drafts because of all the other litigation. Dragon Chain was sued. They're an ERC20 token that's governed by the Ethereum blockchain. Do you think their attorneys aren't going to say, we need Hinman's deposition, we need Hinman's emails, we need the drafts? And then if they are going to go after exchanges like I predicted, you don't think that those exchanges who list Ethereum ER20 tokens are going to ask for the same documents? It's arguably more relevant with an ERC20 token governed by Ethereum blockchain than it is Ripple, right? Because if Bill Hinman said that Ethereum was sufficiently decentralized and an ERC20 token is governed by that sufficiently decentralized exchange, why wouldn't they have rights to see those documents? And since there's already been a decision by a judge that says deliberative process privilege doesn't apply, attorney-client privilege doesn't apply, I could see many other judges saying, yeah, turn that over to them too. And the more people that get it, the more chances it's coming out one way or the other. And then, of course, you have Dr. Layton, Rosalind Layton, who has intervened and is seeking the unsealing of those emails as well. And so I think eventually they're coming out. But yeah, sure, Ripple could agree to drop it if there's a settlement.
What an exciting journey it's been for Ripple Labs, the XRP community, and Link2's global community of investors. With the XRP Las Vegas conference quickly approaching in May, not only will it be a great time to network with the John Deaton and many contributors in the space, but there's a good chance that we may be celebrating a summary judgment favorable to the Link2 portfolio company, Ripple Labs.
No community in crypto, none more deserving of a celebration of good news than the XRP community. That is not even debatable.